I used AI to file fake cases. I proved it in court, and the judge made him send apologies. I'm a civil litigator. Our client got sued over a commercial license deal. We filed a motion to dismiss, and the judge gave the other side a very short deadline. They filed their opposition late and never served us. I pulled it from the court website, opened the PDF, and started reading. My stomach dropped. It looked brutal. It had cases I had never seen, with clean quotes that tore apart our motion and said we used the wrong test. There were state high court opinions that flatly said the opposite of our position. Several appellate cases used a standard I had not briefed. It read like a perfect roadmap to sink my motion. I paused, took a breath, and started checking the sites. I typed the first case into the legal database. Nothing. I tried the party names on the state court's site. A case with that name existed, but the site didn't match. I found a reporter site that matched, but the quote in their brief didn't appear anywhere in the opinion. I tried the next one. Same problem. Either the case didn't exist, or the volume and page were wrong, or the quote was made up. I opened a spreadsheet and made a chart. I listed each case, the quote they used, and what was wrong. By the end, every single site failed. Not one quote was real. I felt relief because I had not missed the law, and shock because a lawyer had filed this with a court. That's when I looked back at the brief itself. The style felt off. It used random M-dashes in places no lawyer would put them. Headings were bold in a strange way. Bullets ignored our local rules. The caption used the judge's nickname, and the lines were out of order. It even said it was signed under penalty of perjury for no reason. In my court, none of that fits. It hit me what happened. They were under time pressure and dumped the facts into an AI tool, copied whatever came out, and filed it. Opposing counsel has been practicing about as long as I've been alive. I don't think he knew that AI can invent authority to back up your point. I wrote my reply that night. I attached my chart. I walked through each fake site with a short note. Does not exist. Wrong reporter. Quote, not in text. I reminded the court that lawyers must be candid with judges. I asked the court to decide the motion on the law and to address the false citations. The hearing was set for the next Tuesday, and I was ready to argue. 2 days before the hearing, opposing counsel filed a motion to be relieved as counsel. He wanted out. The clerk placed it on the same calendar as my motion to dismiss, so he would have to face the judge either way. On the hearing day, the courtroom was full. I set my file on counsel table and kept my chart open. Opposing counsel did not show up. He sent a junior associate who looked brand new. When the judge asked about the citations, the associate said, "We're investigating the matter." The judge turned to me. I walked through 3 examples and handed up the chart. The judge said the statements of law in the opposition were false and misleading. The motion to be relieved was withdrawn. My motion to dismiss was denied, and trial would go forward. The court set an order to show cause in October to decide whether to report the attorney to the state bar for misleading the court. While the OSC was pending, we went to trial. The same associate tried the case. He rolled in with 3 binders, but he could not answer simple questions. He mixed up dates and flipped parties. He kept asking for a moment to find exhibits. I kept my crosses short. Our client's witness held firm. Their key witness folded on a basic timeline. The judge told him to read Noland v. Land of the Free, LP, before the OSC. We rested. We argued. We won on the merits. At the OSC hearing, the older lawyer finally appeared in person. He looked tired and spoke softly. He said a junior associate, who no longer worked at the firm, had drafted the opposition. He said he signed it without checking because he trusted his team, and he was rushing. He said he did not learn about the fake law until he sent a different attorney to argue the motion. He said he fired the person who drafted it and added new review steps for filings. The judge asked why he never withdrew the brief after my reply exposed the problem. He did not have a good answer. The judge weighed both sides out loud. On one hand, there was no real supervision. The citations were plainly wrong, and the signed filing stayed on the docket until the hearing. On the other hand, the lawyer had no discipline history, showed remorse, and had started to fix his office process. The judge cited Noland again and explained what stronger sanctions could look like. Then, the judge ruled. He sanctioned the attorney $750 payable to the clerk. He also ordered him to send written apology letters to his client and to us, and to file proofs of service. Now folks are saying I'm ruining his career over fake sites. Was I wrong?